Finishing now. Another bill comes along in 2004. This is again one I drafted, but this got massacred by the Brown-Blair government, who I hate more than anybody else in the world. We tried an MP called Hal Francis, a very lovely man, MP for Swansea. He came second in the ballot in 2003. He had a child, Sam, who died when he was 15, had cerebral palsy. So we drafted a bill, but there we were trying to sort of bring carers into the equality legislation, effectively. The thing we wanted to do with this was to amend the Disability Discrimination Act, largely. That's why it's called the Carers Equal Opportunities Act. We wanted to amend the Disability Discrimination Act to bring it in line with other discrimination legislation. Discrimination legislation says normally it's unlawful to discriminate against somebody on grounds of, and it can be anything but say race, or association with race. So if I were married to a black woman and I was refused a job, I could claim race discrimination, although it's her race that was the operative factor. So all we wanted to do was to harmonise that and to say it's unlawful to discriminate on grounds of disability or association with disability. Because many carers are in a bad health, wealth, well-being situation because they are indirectly discriminated against, because they cannot work because of disability. They cannot go and see the doctor because of their caring responsibilities. So it's the association with disability. And the Blair-Brown government refused that, Patricia Hewitt in particular, for which I bear a grudge. So all we got in this was there's a duty to provide information. So since then, I think local authority information services have probably improved and often have carers organisations doing that. There's a duty to discuss with carers whether they want to work or undergo education, training and leisure activities. And a duty to cooperate with the NHS. It didn't do a lot, but it sort of indicated the next phase of the campaign, which was to get sort of carers discrimination legislation and to make carers not just the responsibility of social services, but education and health and Tesco's, really, just like disabled people are today. But we failed there. Now, what happened quite surprisingly was, although we failed, a case was taken under employment law that did succeed. In the year 2000, the European Union passed a directive which binds all 27 European Union countries, saying that it's unlawful to discriminate in employment on grounds of sex, race, disability, but also age, sexual orientation and religion. It's called the Equal Treatment Framework. And a set of very good employment lawyers who understood this, and I didn't understand this, took a case for somebody called Sharon Coleman. Sharon is got a disabled son. At the time this happened, Oliver was 7. And she worked for a firm of solicitors who were pretty brutal. And she was bullied, basically. Oliver's got disabilities, he's got breathing difficulties, and so he has to take time off work. She had to take time off work, sometimes sometimes predictably, but sometimes unpredictably. And they just gave her a very hard time indeed about this. Other people could take time off work, but she was victim, and it's the only, my students love reading it because it's the only European Union judgment that's got the F word 4 times. Because, they were just saying, you're effing child this and you're effing child that. So she eventually had to give up work. She did them for constructive dismissal. Now, of course, she loses under British legislation because the only thing she could use was the Disability Discrimination Act, and as I've already said, that makes it unlawful to discriminate against a disabled person on grounds of disability. Sharon's not disabled. But the Equal Treatment Framework Directive made it unlawful to discriminate against a person for a prohibited ground. And she wins on that because she was treated badly because of disability. So suddenly, carers in 2008 were held to be protected by association. That was quite a breakthrough. And there we see that picture I was talking about earlier. We see Michael Oliver's book. This is the classic example of a disabled social model of disability. He can't vote, not because he's got no use of his legs. He can't vote because of the environment we've created. We have disabled him socially. But it seems to me that you could get a sort of similar image for carers. Now, this probably wouldn't work because the carer can run in and then vote and run out. But if it was, I don't know, he needed a CT scan or a radiology, then that would be difficult because they'd have had to have made arrangements beforehand because this was going to take time. Carer can't access these services because they are handicapped by the disability. They have to make sure that the person in the wheelchair is being looked after. I mean, GPs often used to say, I don't think they do it anymore, say you had to make an appointment on the same day to see a GP. Well, that's very hard for carers who have to sometimes make appointments 2 or 3 days earlier because they need to make these arrangements. So carers are disabled, effectively, from accessing quite a lot of services because they can't do it without having to already accommodate disability. Now, really finishing, because of the European Union judgment, the law was changed. The law had to be changed because the European Court of Justice in Luxembourg is binding on the British courts. And so Section 13 of the Equality Act, which repealed the Disability Discrimination Act, the Race Relations Act, the Sex Discrimination Act, all those acts have gone. We now have a single Equality Act. And that Section 13 of that says that it covers people by association. So it's now unlawful to discriminate against somebody against disability or age or sexual orientation or religion or by association. So we now are in a situation where carers are beginning to be protected under the equality legislation. If you'd said to me in 1970 that disabled people were going to have disability discrimination legislation, I'd have said you were mad. I would say, no, I mean, I can understand sex and race, although, of course, those only came in the 60s. But obviously it's wrong to discriminate on grounds of race and sex because those are irrelevant factors for most activities. But disability is different. Disability, you can't do certain things if you're a disabled person. If you're blind, you can't be a driving instructor. I don't want to be brutal, but it's a fact. There's lots of things disabled people can't do. So it's different to sex and race. And so in the 70s, I would have said very clearly, disabled people are not the subject of discrimination legislation. But of course, we now say they are. And we all think it's obvious that they are because the social model made us look at it differently. When I say carers are going to have rights under the equality legislation, just like disabled people, because at the moment they only get it vicariously by association, people say, oh, no, that's not right, because carers are different. Because it's obvious that disabled people, sex and race are different, because that's innate. You can't do anything about it, whereas carers is choice. Well, I don't know about that. Most carers don't talk about choice, choosing to be carers. Most people talk about caring a bit like disabled people talk about disability. But of course, we've now extended discrimination legislation to include age. Well, maybe you can't choose age. I wish we could, but you can't. Sexual orientation, well, sexual orientation is quite complicated. Maybe that changes. But we also include religion. And of course, religion, for me, is a choice. I mean, I think people choose it. I've got a sister that's had 4 different religions. So the idea that you're hardwired into religion, I think, is stretching it a bit. So we have extended equality legislation to include non-innate factors. And of course, carers can argue that they are discriminated, not because of, but they are included because of the social model. It is society that is disabling, the very bad way society is treating them. And that is very similar to the way disabled people would articulate their experience. So we're there, 20 past. Sorry, you've all been very quiet, probably desperate for the loo. I don't know if there's any brief questions, but we've got to our allotted period. Okay.
Can I just say, carers are not volunteers,
No.
they're constricted.
Yeah, I think that's a much better thing. Yeah, it's forced, coerced labour. It's not slavery, but it's forced labour.
Yeah.
Yeah. Anyway, thank you very much for listening. It's been-